I was simply, I led the legal team, but there was a lot of other people behind this as well. Laura Ann van der Westhuizen is here today. She'll be coming up and tell me the answers to your questions at the question and answer session. Sam Webster also was very much part of the team. Elaine Motion of Balfour Manson. So there were a lot of us behind this. But as I say, it's the legal team. We were asked to advise on the legalities of the 2014 Act and the provisions which it made in terms of named persons. But as you know, when you seek a lawyer, you get a hired gun. That's what we are. We were asked if there was a possibility of taking this and challenging it before the courts. We advised on that, and we then argued to the best of our abilities. If somebody else had asked us to argue the opposite, well, that's, I'm afraid, what we do. So, lucky you got me first. So, I've been asked really just to, as it were, give some idea of the process of how it is that this matter came to court in the first place. And, you know, it's, as I've said before, what the case shows is the Constitution working. I'm a lawyer. We work in an adversarial system. There's never been a confrontation I haven't liked. And so you're asking me to do my job, but one has to remember what the job is. In the Constitution that we have in Scotland, we have a Scottish Parliament elected by us. The Scottish Government is answerable to it. But unusually, relatively unusually for Britain, but common throughout every other country in the world, there are actually limits placed as a matter of law on what the Parliament can do. And so what we were asked to advise on is, have those limits been in any sense breached by the Act of the Scottish Parliament? If this had been an Act of the Westminster Parliament, there was nothing one could do, because the UK Parliament is supreme. But the Scottish Parliament is in a different position. Ultimately, issues as to whether or not what it has done is within its powers is a matter for the courts to determine. But I don't think that should be seen necessarily as a confrontational aspect. It's the way we have our constitution working. In Westminster, in London, you have the democratic element of the House of Commons. Then you have the not-so-democratic aspect of the House of Lords reviewing what the House of Commons might do. You get a second bite at the cherry. You get the idea of stopping and thinking, of experts from different fields, not answerable to an electorate, saying, are you sure that's exactly what we need within a democratic society? And sometimes asking the House of Commons to look at matters again. In the Scottish Parliament, the idea was set up that there was only one chamber. There was only one bite at the cherry. The idea, I think, was that the committees of the Scottish Parliament would be quite powerful and would therefore question matters and test government proposals much more strongly. But in the way of things, certain matters, such as the named persons, what happened was a general consensus among the political parties seemed to grow round it, because it's about protecting children, and who can be against protecting children? So the legislation was not subject to the detailed scrutiny that really one would have hoped might happen within a properly scrutinising chamber. And it went through, I think, also without very much public engagement or public knowledge of it. So the only possibility for looking again at matters was by taking matters to the court. And that is precisely what was done by the no to named persons campaign, and through your support, all of your support, they were able not only to fund such a challenge, because it's not an easy thing to do to take the government and Parliament to court. It requires deep pockets, because if you lose, you're left with not only your lawyers' costs, but the lawyers from the other side's costs. And also you need faith that it's worth going through every step of the process. This was always going to be a case, I think, which ended up in the Supreme Court, because it was too important on both sides for it simply to be left before the lower courts. So it was a long-term campaign with people who had faith that ultimately they would get the right result and were willing to risk substantial amounts of money to do that. Now, so that's why challenging what the Scottish Parliament does is relatively unusual, because it's terribly expensive and really rather difficult. And so at some levels you can say, well, our constitution is not working as well as it might do, but it's what we have. The fact is, it got to the Supreme Court, and all that means it gets before 5 lawyers. At some levels you think, well, what do lawyers know? Not a lot. They know about law. They know about law. And what we like as lawyers, are nice, precise, neat words that say what you can do and what you can't do. And so we all know where it is that we stand. Because legislation is all about compulsion, really. That's why you put things into law, because it gives the powers of the state to say that you have to do this or you must not do that. So precision in the wording of legislation is just what lawyers expect, and expect for all of us, because you don't want there to be too much power with vague wording leading to non-accountability. If the state says, well, we're going to check on matters which are really matters of individual opinion. So when the Supreme Court saw the manner in which the legislation had been drafted in this case, I think there was generally shock, actually. We don't expect legislation to use the language of social work. The language of social work, great if you're a social worker. But if you're a lawyer and if you're a judge, you think, what does it mean to be safe, healthy, active, nurtured, achieving, respected, included, there was another rather, responsible? Gosh, I wish I were all those things. But the idea that if you failed in any of those, you potentially then that set up a whole series of state intervention and potential escalation, that you think, gosh, that doesn't feel quite right. Of course, it's a perfectly laudable aim to want the best for our children, to make Scotland the best place to grow up in, which was, in fact, one of the stated aims of the legislation. You think, well, motherhood and apple pie is absolutely fantastic. What's not to like? But the devil is in the detail. And the problem was that when it came to the detail, the wording was just so squidgy that the judges thought, well, what exactly does this mean? Now, it's very difficult, generally, because judges and lawyers are not democratically accountable, to persuade any court to say that we are going to strike down what a democratically accountable legislature has done. One can understand that. The people elected the MSPs. If they don't like it, then you elect somebody else next time round, and they will reverse whatever it is that's objectionable. You lobby your local MSP, and eventually there'll be some kind of amendment. That's how things are supposed to work. So to get a court to have to suggest, well, actually that's not working, is really a very, very high hurdle. And the court will say, look, if there's any way at all, in which this legislation can be read in a manner which does respect basic fundamental rights, then it will pass the test. It will not be up to us to strike it down, because we will presume that anybody applying or using the Act will comply with their other duties. And the court, therefore, the Supreme Court, proceeded and looked at the named persons legislation on that basis, saying, well, we'll presume that you will, in fact, the named person will comply with duties to respect privacy, your human rights, will not go overboard on that. So even with that presumption, however, it looked at the legislation and said, but this legislation is incomprehensible. As lawyers, it doesn't make any sense, because, and it also presumes that anybody applying or interpreting the Act has this astonishing back knowledge of what human rights requires, or what data protection requires, or whatever, because the Act itself doesn't tell you. It just speaks in this vague language of aspiration when it should be talking specifically in terms of obligation. So that's why the court said, not that this was a disproportionate interference in family life, but they said it's not in accordance with law. When we try and read this, it doesn't tell us what the duties and obligations and rights are. It presumes far too much. The court didn't just look at the legislation when it said that, it also looked at the guidance that had been published. And the guidance was written in even more social workese. I'm not wishing to knock social workers. I mean, people can talk about legalese, but lawyers are used to dealing with legalese. The guidance was even bigger than the Act. It was hundreds of pages long, and it was incredibly difficult to actually work out who could do what and why. You just got these broad statements of niceness at the beginning, and then pointing out that in some cases children have been harmed, and that therefore all those involved in child services had a major duty to ensure that children's well-being was then going to be promoted. But then it would say, almost in passing, and remember the human rights. But there was no real reference to families, to the need for actually getting people's consent, and that parents are actually probably, for the most part, to be presumed to be the best caregivers for their children. All of those things were brought up, highlighted, and found within the judgment of the Supreme Court. I reread it because I don't normally like going back to reading cases I've done, because I think, why didn't they say this, or why didn't they take that argument? But actually, rereading it, it's actually rather good. In the sense that it does actually highlight what the existing law is in terms of data protection and human rights, and does tell you. So I think if you ever want to look at it, paragraphs 48 and 50 are really very useful, because they tell you what the situation is here and now. Whatever the case, with the named person legislation not being enforced, it's a question of data protection. If new named person legislation comes in force, it will still be subject to these fundamental protections in terms of the need for consent, the respect for privacy, particularly in matters which really ought to be confidential in terms of one's health, medical history, and the like. No matter what is ultimately produced by the Scottish Parliament, those fundamental standards still remain. So, as the Supreme Court says, you're always going to have to read and understand the named person, any legislation, any Scottish legislation on named persons against those basic fundamental principles. And the court has usefully outlined, highlighted, in a sense, stating what really ought to be the obvious, that the relationship between parent and child is the starting point. Its parents are important. And interestingly and powerfully, the court does remind one that the respect for families, respect for allowing families as being the basic building block of society, is actually tied up with what it is to be a democracy. I know these are big words, and one doesn't want to get over the top. Well, one really ought not to get over the top before the courts, because you've got to persuade them round. But it is significant, no matter what is said, that the court actually refers to the dangers of totalitarianism within its judgment. That is an important reminder to all of us that there are, yes, the state does and is there to do fantastic things, organising and protecting health service, child protection, allowing us to live in freedom. And that's what the state is for, and there's always a temptation that power might be abused, and that's why we have the courts. So, as I say, I don't see this as being a confrontational aspect. I see it as the Constitution working as it should do. I'm just sorry that it does require so much application and money to actually have to be able to get the Constitution to work properly. But it is where we are. But we do have this, I think, rousing and important judgment, which does show that sometimes it is worth going to court. Okay, thank you.